Good afternoon, Council. We're here today in the matter of Paulson versus Diamant. We have an oral argument today on a motion for summary judgment. We'll hear first from counsel for the moving party, the defendant. Counsel, why don't you introduce yourself and proceed?
May it please the court, Your Honor. My name is Dylan Porter, and I represent the defendant, Al Diamant. Would the court like a recitation of the facts?
Briefly, please.
Carl Paulson attended a party at his girlfriend's apartment building. She told him he was not allowed to come to the building for the party. She told him to leave when he walked through the door of the building. Ed Morris was another tenant who was forced to find off-campus housing because he had a number of incidents at Hilltop College. He got in a fight with Paulson, resulting in Paulson's death. There was an efficient locking system for the building. However, people left the doors open that night. There was a sign on each entrance to the building that said, "No solicitors or people uninvited by tenants may enter this building." The leases forbid students from having parties with a clear statement that says no parties. The defendant is the landlord. The landlord was not aware of any parties in the building or any crimes. There were 200 students that night with 10 or more kegs of beer and illegal drugs. Officer Wilson had visited the building around 30 to 40 times because of loud parties. The police never informed the landlord about the history of crime in and around the building. There was once a report of several injuries at the party there involving a mosh pit. There have been assaults in the block around the building. There have also been occasions where there were reports of stolen property due to break-ins. The landlord was aware of a little vandalism of cars. He hired a security guard to patrol the parking lot 2 or 3 times a day. There are 2 issues before the court today. The first issue is whether Carl Paulson is a trespasser. The second issue is whether harm to Carl Paulson was reasonably foreseeable. Your Honor, the court should grant the defendant's motion to dismiss for the following reasons. First, because the landlord cannot be held liable for negligence, since Carl Paulson was a trespasser. Second, because the landlord cannot be held liable for negligence because harm to Carl Paulson was not reasonably foreseeable. The court should find that Carl Paulson was a trespasser because he did not have an invitation, which is either express or implied conduct that justified his belief that a tenant desired him to enter.
Does it have to be the tenant who desired him to enter?
Absolutely. In the precedent Monterosso, the plaintiff got injured in a landing off a common hallway when she fell. The defendant leased a store which provided entrance to the common hallway by advertising signs through the back door when it was unlocked during business hours. The plaintiff fell when she tried to use the bathroom, which had no sign on it indicating that it was private and could not be used by the public. The court held the plaintiff was not a trespasser. The court reasoned the plaintiff had reason to believe that she could enter the bathroom if she so desired because there were signs advertising the back door while the bathroom was not labeled private or marked out of bounds. The plaintiff did not lack an invitation because there was conduct that justified her believing that the possessor desired her to enter the land. Unlike Monterosso, where the bathroom had no sign on it indicating that it was private, here there was a sign on each entrance of the building that said, "No solicitors or people uninvited by tenants may enter the building." The court should, following its reasoning for Monterosso, find that Carl Paulson was a trespasser because there was conduct that would not justify his belief that a tenant desired him to enter. Here, his belief that he was invited was not justified because a tenant told him he was not allowed to come to the building. While he may have previously thought that it was an open invitation for him to enter, he was definitely aware that he was not invited.
Well, wait a minute. So if there is an open invitation and one tenant tells him that he can't be there, why does the word of that one tenant trump the open invitation?
Well, I was just about to get there. Essentially, because no tenant told him he was allowed to come to the building after the tenant told him he could not, is very clear to him that he was not invited.
But if there are 18 units, right, in the building?
Yeah,
And there are about 3 people per unit?
yeah.
So we're talking about 48 people. So let's say hypothetically, 47 people have told him that he can come to the party. And the last person to talk to him tells him he can't come to the party. Does that mean he can't come to the party under the trespass rule?
Essentially, if another tenant in the building invited him, he would absolutely be allowed to go there. But there is nothing in the record suggesting that any such person or tenant invited him to the building for the party. Therefore, it was very clear to him that he was not invited.
Now, you also claim that this attack was not reasonably foreseeable, right?
Absolutely.
Can you give your best argument for that?
The court should find that harm to Carl Paulson was not reasonably foreseeable because a landlord only has the duty to provide adequate security if he knew or had reason to know of a threat to the safety of persons lawfully on the premises. In Whitaker, an assailant raped the plaintiff in the basement of a publishing company's office. The landlord did not have reason to know of any previous crimes in the building, while was aware of theft of contents of vehicles in the building's parking area. The court held the landlord did not have a duty to provide adequate security because the attack was not reasonably foreseeable. The court reasoned there was no evidence that the landlord knew or had reason to know of a threat to the safety of persons lawfully on the premises against which the landowner could have taken reasonable preventative steps because the personal property crimes had never occurred in the office portion of the defendant's building, and there was no evidence that the assailant was in the course of committing any personal property crime.
But in our case, we have dozens and dozens of crimes that have been reported at this building. We have underage drinking parties, we have rowdyism, we have property crimes, we had a violent brawl outside. Why don't those give notice to the defendant that he should have expected that this attack would occur?
Well, like Whitaker, where the landlord did not have reason to know of any previous crimes in the building, where the plaintiff was raped while was aware of theft of contents of cars in the building's parking area, here, the landlord did not have reason to know of any crimes in the building while was aware of a little vandalism of cars in the neighborhood. The court should, following its reasoning from Whitaker, find that the attack was not reasonably foreseeable because he neither knew nor had reason to know of a threat to the safety of persons lawfully on the premises. Here, the landlord never spoke with the police about the history of crime in and around the building.
Does it matter if he never spoke to them if a reasonable landlord would have known about the history of crime?
While he had not contacted the police, he was not willfully ignorant about what was going on and around the property, because he took action by bringing a security company to patrol the parking lot 2 or 3 times a day to prevent the vandalism of cars which he was aware about, suggesting that the landlord absolutely was not willfully ignorant about what was going on and around the property, because he would have taken action had he had been informed of what was going on. As a result of him not being properly informed, the court should grant summary judgment.
Thank you, counsel. Let's hear now from counsel for the plaintiff.
May it please the court, Your Honor. My name is Philip Kochi and I represent the plaintiff, Chris Paulson. Your Honor, the court should deny the defendant's motion for summary judgment for the following reasons. First, because my client was not a trespasser, and second, because the events that took place at 149 Bolton Street were reasonably foreseeable. Mr. Paulson was not a trespasser because there was an open invitation to the party. The door was propped open so guests could come and go as they pleased, and my client was invited to come party with his friends while he was inside of the building. The case that best helps demonstrate that Mr. Paulson was not a trespasser is Monterosso v. Godet. Customers who regularly went to the consignment shop knew there was an entrance through the back door, located inside and down a hallway within the strip mall. As the plaintiff entered the back door, she noticed a bathroom on her left and decided to use it. When the plaintiff went to walk towards the bathroom, she fell down a flight of stairs and ended up being sent to the hospital. The court held that the plaintiff was not a trespasser and entitled to damages. The court reasoned that the defendant had a right to be in the hallway, as well as the court reasoned that, based on a lack of signage and proper safety regulations, the defendant was responsible for the damages. The facts in the case at hand are essentially similar. The building at 149 Bolton Street was known for being a party house and was known for having an open invitation where anyone could come.
Does it matter that the decedent's girlfriend told him she didn't want him at the party?
At the night when she was told my client that he was not allowed to come to the party, there was an argument that took place. So there could have been a misunderstanding where he could have thought that she didn't really mean what she was saying. So by him continuing to show up to the house where it has been known that an open invitation to this place where he knows he's allowed to be invited to come, and that even though she lives at the premises, there's other tenants that live there as well that he is friends with, that makes him able to come to the house. Secondly, the events that took place at 149 Bolton Street were reasonably foreseeable because the area was known as the student ghetto, where many crimes have taken place, and there have been fights that have occurred on this property prior to this night. The case that best supports this argument is Mullins v. Pine Manor College. The plaintiff in this case was raped by a trespasser who was able to get over a short fence at the college into her dormitory and proceeded to walk around the campus while being able to avoid guards who went on a 15-minute shift around the campus. The court held that these events were reasonably foreseeable to expect because the night before the incident, as well as a year prior, there were break-ins where the intruders were able to roam around outside and inside of the campus without being caught. Your Honor, the court should deny this motion for summary judgment because my client was not a trespasser and the events that took place at 149 Bolton Street were reasonably foreseeable. If the court has no further questions, I would rest on my brief.